Good morning. This is Judge Alyssa Perez presiding over the 210th District Court Civil Docket for April 13th, 2022. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we're streaming all matters live via YouTube for public viewing. Mr. Marufo, would you call our first case, please?
On page 1, the second one, Judge. In cause number 2022 DCV 0054, Eduardo Contreras et al. Versus Carlos Nunez et al. Announcement of council, please.
Victoria Terrazas, on behalf of Mr. Quiñones, representing Eduardo Contreras, plaintiff.
Marwan Bhatti, on behalf of the defendant counterplaintiff Carlos Nunez.
Brown, on behalf of the defendant Joel Luna, DBA Optimus.
Good morning, folks. So we are here for a scheduling status conference, and I think the only thing I have in terms of a future setting is a jury trial in 2023. Tell me a little bit about what we're doing on this case. Normally, we would enter a scheduling order to the purpose of the hearing today, but how are you all wanting to handle this one?
Judge, and I'm speaking on behalf of the defendant here, but we had a temporary injunction recently that the court signed off on, and there was a trial date, I think, entered into that order of April 7th. So I just want to make sure that was on the, I guess, the court setting for the court. And then I wasn't sure if the court needs a pre-trial setting before that.
So, normally we would have our standard scheduling order with all kinds of deadlines, an agreed mediator, things of that nature. So I just want to make sure that this case can follow that track, or if you all had something else in mind, we certainly need to put interim dates because the only thing that has been said is that one is the trial date. So, normally we'd have a docket call and all kinds of deadlines before that.
Good morning, Judge. I'm sorry, my sound was turned off. I apologize.
Mr. Blankenship, are you here on the Contreras case?
I'm sorry. No, I'm here on Adame versus Galvan, Your Honor.
Okay, we'll get to you in just a second. Thank you.
Okay.
Judge, we would like a scheduling order in place. I can agree to one with the other parties, or if the court has its preferred scheduling order, I'm fine with that, but I would like to move the case along and have deadlines in place.
Okay. Are you all good, Mr. Brown, Mr. Terrazas, with the court's scheduling order? No need to, I think we'll just do that. So Myrna, if we can go ahead and send counsel all the scheduling order circulated. Have you all discussed any type of mediator? I mean, any agreed mediator, not any type, but any agreed mediator. If you would, when you return the scheduling order, if you will include that as part of the order, and we will have a setting in 2 weeks. We will still go based on that jury trial date of April 7th. And so you can anticipate, I hope I have the right calendar. Yes, an April 5th docket call, I think either final judges or a final civil pretrial that will correspond with the mediation deadline.
That sounds fine, Your Honor, and I'll talk to counsel about agreeing on a mediator ahead of time.
Okay, so we'll have a setting in 2 weeks for you all to return the scheduling order. Of course, if you have not done so by that hearing date, then you all will need to appear. Okay.
Thank you.
Thank you very much.
Thank you.
Mr. Brown, you good?
Judge.
Yeah.
Yes.
Okay. Perfect. Thank you all. Take care.
Thank you, Judge.
Who's next?
Judge, Mr. Blankenship said he's here, but I show it canceled. The case being rescheduled for 4/27.
Let me double check. Correct, Mr. Blankenship. If you're, let me see. Which one is this one? Is it on? I'm sorry. Which one are you on, Mr. Blankenship?
Adame versus Galvan, Your Honor. It is.
Your Honor, Jeffrey Borshaw here. I'm the plaintiff's counsel on that case.
Let me see, Marcela Adame. I don't know why this one is not, let me go back.
I made a mistake for 0643. That one should not be canceled.
Okay, Well,
Sorry about that.
that'll solve that problem. Let's go ahead and call that one.
In cause number 2021 DCV 0643, Marcela Dame versus Maria Galvan. Announcement of council, please.
Jeffrey Borshaw on behalf of the plaintiff.
Mark Blankenship on behalf of the defendant.
All right, gentlemen, we're here. Final status conference. How are we doing? We got a jury trial set for early June.
Yes, Your Honor, and we just, Mr. Blankenship's office, I believe, just filed a joint motion for continuance. We've just need to wrap up a couple of discovery issues and we need to get the case mediated. And it's probably one that I think we can get resolved. So we filed that motion for the court's consideration.
Do you see it, Ms. Rios, by any chance? It's not reflected in Odyssey. If it was just filed this morning, there could be just a little bit of an administrative delay. What type of turnaround time are you looking for a new trial setting?
Your Honor, I don't want to speak for Mr. Blankenship, but if we can get the case mediated by May and get all of our minor discovery issues resolved, I think we could be ready for trial late summer,
Okay.
early
So,
fall.
if that sounds like it's workable, I know sometimes scheduling the mediation is part of the issue, but I just assume leave it. If there's a realistic potential for this being resolved, leave the settings as is, and I would extend the deadline to mediate to, I guess that's what, June 30th? Let me see. Yeah, June 30th. Why is 6/1 of it? 6/1/2022. Yeah, all right. Okay, so then that'll get us, I'm sorry, to May 31st. I was thinking the wrong month. May 31st, that would be right before the holiday. I know it kind of still keeps you on a tight timetable, but I would go all the way to the docket call day to see if you all have that mediated. And at that point, we can look if we need to get you a new trial date. The court does have some flexibility with the, potential of reopening the process for getting jury panels and all that. We have some openings, so it could probably still fit you in either in late July or early August. But if I can leave the settings for now, I'll look at that joint motion for continuance and kind of hold it and just see how you all do it at mediation. Is that all right?
Yes, I think that's fine, Your Honor. And it is, like you mentioned, it is just an issue also getting the mediation scheduled. Everyone's pretty booked up right now. So just getting that on the books in a timely fashion is going to be the main challenge, but we'll come back and apprise the court once we've got it done.
Okay. Mr.
I agree,
Blankenship.
Your Honor.
Okay, perfect. So I'll keep my eyes peeled for that motion for continuance, but I'm going to leave the settings for now. What I think we will need to do though, or can do, is cancel. Myrna, if we could cancel that May 4th final civil pretrial, because I don't think we'll have any updates before then. Okay, so we'll just see you all on that DACA call date. Feel free to email the court and let us know if you have that scheduled ahead of time and find out that it's resolved. We'll fix the settings accordingly, okay?
Very good, Your Honor. Thank you.
Thank you, Your Honor.
Thank you very much. Y'all take care.
Bye-bye.
Okay, who's next?
Top of page 2, Judge.
Okay, go ahead.
In cause number 2020 DCV 2000, Arthur
Beganowski.
Beganowski versus State Farm Mutual Automobile Insurance Company and Thomas Craig Matthews. Announcement of counsel, please.
Good morning, Your Honor. Daniela Rabinotti for the plaintiff.
Cliff Jessup here for defendant State Farm, Judge.
Good morning. So we're here for our final status conference and we have a jury trial in July. How are we doing?
All right,
Yeah.
Judge. So, I'm going to take charge, Judge. I'm the plaintiff's counsel. Judge, as the court knows, this was a very heated last hearing. And I told the court that the court needs to rule on the motion for protective order to set aside the felony conviction that was in 1998. And Judge, I've been an attorney much longer with Mr. Jessup, and I've never seen an attorney request the court to have a conviction of over 10 years to go into the trial. This is only done for harassment, and there is case law that I submitted to the court. We had our hearing, if the court remembers, and there was some confusion, or I guess the court was unclear on the time of the release. We read the statute, and I'm sure the court remembers that argument where, you know, it wasn't clear, was it because there was some argument that he got released and he went sent home, and there was an issue with the confinement. So I guess Mr. Jessup was trying to calculate for the court whether it was truly 10 years or was it less than 10 years. So because I wasn't clear on that, Judge, and I couldn't swear to the court that my calculation was 10 years, the judge ordered us, and I'm just refreshing the court's memory, that the court wants us to go to deposition and ask Mr. Beganowski under penalty of perjury the specific date of his sentencing and the specific date of his release. So that was the court's order. So the judge can make this ruling. And I told the judge, this case will not settle. This case will not go to mediation if you don't make that ruling, because that's not something that we're okay. I mean, we're going to take that up if needed, but I have not seen a felony conviction more than 10 years to go in court. So I said, okay, then let's just do this deposition. Well, Judge, we take the deposition, and I was right. This is not about following the law. This is about harassing the plaintiff, because Mr. Beganowski in 1998 was found guilty by a jury. So I let the defense counsel ask those questions because I know the judge wanted those answers. So I wanted to provide those answers to the court so they can judge, make the right ruling, make the right decision, and follow the law. Well, I can read from the transcript. We even got the transcript. My client, Your Honor, was released from the institution in 2009. Exact 2009, and because of good behavior, he was allowed to go home in 2010. Okay, he says, I got page of his deposition, page 10. I got out of prison in 2009 in October. I was released on what was called the senior release program for people over 65 who had done well in prison. I was the first one released in the United States, and I was released to home confinement in El Paso County, and 1 year on home confinement to finish my sentence, which I finished in October of 2020. So again, even if we take the last day of the completion of the sentence, that's October of 2010. And the deposition, Your Honor, did not go over the motor vehicle accident because the defendant, who, by the way, it's my client's own insurance company, my client's own insurance company, who sure did not tell my client, oh, you're a convicted felon, we're not going to accept your premiums. But now that it's time for them to pay, even though they've taken premiums for him for many, many years, now he's the convicted felon, and now they want to bring this up. So the deposition was not even about the car accident, Judge. They didn't even ask question about the car accident. But what Mr. Jessup was interesting in that deposition was, let's talk about that case. Let's talk about the case of 1998. Didn't you have co-conspirators in that case? Judge, I had enough of it. I told him this deposition will stop right now. I wanted to call you, Judge, but I didn't know what was going on and I didn't want to bother the court. But this is very serious. I've never really had to make this argument. At most, Judge, if the felony was less than 10 years, the court only allows this question. And I've tried many cases with my felon convicted plaintiff. You are a convicted felon, yes? Yes. And that's it. You cannot go into anything else. You cannot ask any additional questions. That's if it's less than 10 years. This is in 1998, and he wants to harass my client for a motor vehicle accident who happened in 20 years later because from his own insurance company, Judge, from his own insurance company. If this is not bad faith, I don't know what it is. We wasted another time in mediation because their only hope and argument is that the court makes that error of letting this evidence in to prejudice the jury. This is wrong, Judge. This is wrong morally, ethically, legally, from so many aspects. And what I am not siding here with Mr. Beganowski, whatever he did or he didn't do in 1998. But this is a car accident case, first party claim. And for any insurance company whose CEO made $40 million last year because apparently didn't pay this, this car accident, to come here and treat people this way, their own insured, the court should not allow it. The court is the gatekeeper of the evidence. This is a violation under any rules. And I completely object, and I beg the court to come up with a ruling, because they're not going to participate in mediation in good faith. We're not going to have a trial judge until this is addressed. This is a serious matter, and I have called many lawyers in town, and everybody else has had the same shocking, angry, just outburst emotional that I am having, because it shouldn't come to this. I've had clients that have had 7 felony convictions, and only one question was allowed in court. Are you felon convicted? Yes, that's it. He wants to try my client's 1998 case and ask about what happened in this case and bring in the conspiracy and all of that. I mean, I understand going to law school gives you a license to do things, but not to harass people and not to ignore the law. So, Your Honor, this is where we are. I'm very, very upset in this situation, because it should have not even come to this. My client should have not even been allowed to ask those questions. This should have been an automatic denial, but we provided this information to the judge right now, and I'm asking the court rules that this be stopped. I want a protective order that this harassment stops, so that we can try this case on the merits. A car accident. Oh, and by the way, Judge, the third party liability, which was JLJ, the person who caused the accident, tendered, or very much close to tendered. But my client's own insurance company, State Farm, is treating my client like this.
Okay, so I do remember, just a second, Mr. Jessup. I do remember very well the hearing that we had before. And my recollection, it could be wrong, but my recollection was that there was a kind of cover our bases. I thought the parties had requested that the court not yet rule until we had the deposition. So that was part of, I guess there was some thought that by having that deposition, maybe it would bring us some clarity. Maybe on certain things it did or not. And Mr. Jessup, obviously I'll let you respond here. But I think my last notation, I didn't forget it. It's been sitting on the side of my desk here since we had the hearing, is to, and this I don't recall per se from the hearing offhand. I think maybe I do, but I'll let Mr. Jessup refresh my memory on this. Is what is the overriding, I guess, probative value of having this information be part of this case? And then anything else that Ms. Labinati mentioned, feel free to address.
Sure, Judge. And there's a couple of issues. Number one, obviously, is the release date. And in our last hearing, we discussed this at length, and there was a question whether it was a release, a probation, or parole.
Yeah.
I did start asking that to Mr. Biganowski in his deposition. I also started asking him about the facts and circumstances of his conviction. Again, he didn't plead guilty. It was a trial. I started asking him about these things. And that's when Ms. Labinati called a halt, as she discussed. Now, Judge, if you recall in the last hearing, you know, the court we needed to flesh out these issues before. And this court asked Ms. Labinati if her objection was to use it for all purposes or all trial purposes. And she says, and I'll read from the transcript, Judge, and just so you know, we barely got the transcript from the deposition and the transcript from the last hearing, and we have a motion we're preparing to file, so we can certainly brief the court with more detail here shortly. But Ms. Labinati said, Your Honor, and this is on page 23 of the transcript at our last hearing with regards to, I told the court I was intending to get into his criminal convictions and his release dates and incarceration in the last deposition, or in the last hearing during his deposition. I said I would do that. And when the court asked clarification from Ms. Labinati, the court said, and so Ms. Labinati, with respect to your opposition and motion to exclude, I'm assuming that means for all purposes, not just for trial purposes. I mean, Mr. Jessup and then Ms. Labinati. No, Your Honor, for all trial purposes, Your Honor, not for, I mean, if they want to ask in deposition, I don't have a problem with discovery. I mean, in discovery, you can ask any question. And so, Your Honor, I was trying to get the nature of the conviction, the timeline, and all of those things. Now, in terms of the relevance, Judge, there are medical records that have been produced to us in this case from the Mayo Clinic, where he treated, he received surgery, he went back months and months later, and nothing was mentioned about the automobile accident at issue in this case until several months later, when there's an annotation that he goes back and tells his treating physician at the Mayo Clinic, oh, by the way, your records are wrong. This is actually related to a car accident. And the reason why that's relevant, Judge, is, as people are well aware, is the reason he was convicted was for conspiracy to commit fraud, and particularly against insurance companies where medical records were changed and altered to be more favorable. So, Judge, I was going to ask him about the nature of his conviction. so that we could have this information and have the court can make an informed ruling on those things when the deposition was stopped. I certainly am not intending to harass anybody. I'm not going to try to retry him, but I do think it's relevant in this case, Your Honor. It goes to the modus operandi. It goes to the nature of the convictions. And again, Judge, it's information that we need from him so that we can understand the nature of his conviction, what he's convicted for, and his sentence, Judge.
Judge, that's not the law. I filed a motion with Supreme Court opinion, even with felony convictions less than 10 years, the defendant has to meet the burden of relevance and prejudice. I submitted case law that says 7-year-old felony, it's still too prejudicial, was not allowed to go in. When it's over 10 years, the court doesn't have this is over 10 years, the court doesn't have a choice. Every bet, I would love to be able to use felony convictions on every case where the defendant is not telling the truth. Anything, any evidence, bad or good, goes to defendant's character. If the lawyers were allowed to play this shenanigan game, then the Supreme Court and the Texas Court of Appeals and our courts up there, we're going to, not have this law. There is a law that says anything over 10 years doesn't go in, period. So that is not true that I made this agreement to allow questioning discovery. The only question I allowed to agree to allow is the exact time of his release, because I wasn't sure. The judge asked me when is considered completion of judgment, the release of confinement when he gets out of jail, or the completion of his home confinement. That was the question the judge asked me. I could not give an answer with certainty. So that's what I said. You know what? That's fine. We can ask Mr. Briganowski that at the deposition to give us the exact answer so I don't give a wrong date. But as far as anything else, I have filed 2 motions with the court. I have submitted significant case law to the court, and defense counsel or myself, if this was me trying to break the law and have prejudicial evidence and evidence that I'm not supposed to go to trial, I can make an argument. Oh, well, everything is a character. Well, everything goes to the character. What does that have to do? The records are from the Mayo Clinic. My client did not own the Mayo Clinic. My client does not own or operate any of the providers that treated him. He got treated by the Mayo Clinic, Judge. He has no connection, no relationship, no partnership, no ownership with the Mayo Clinic. For God's sake, Judge, it's the Mayo Clinic. It's not even a company here in El Paso, Texas, or one of those doctors that maybe is a friend of a friend. How many cases we have the Mayo Clinic? Judge, ask any plaintiff's attorney that is here, raise their hand if they think there is any case law in the state of Texas that would allow this evidence. Mr. Jessup is making very unintelligible arguments. There is no basis for him to say, oh, in 1998, he was found guilty on insurance fraud. So his surgery that he had in his back, that's fraud too. He cut himself, Judge. He was cut. He was cut by the doctors at the Mayo Clinic. They said he needed surgery. He testified. He tried his best not to have surgery. He didn't want to have a surgery. What? He got with the Mayo Clinic to fraud for his own insurance company? Come on, Judge. If they felt this bad about my client, then they should have not had him as an insured. They should have not accepted his money for all those years that they did. I think making $40 million a year in CO, that has to do some fraud, Judge. So, if this is going to go, I want to go into all frauds against State Farm. I want to bring all the evidence that any plaintiff's attorney in the United States of America has filed against State Farm for fraud, for breach of contract of good faith and fair dealing, for all those plaintiffs that have been screwed by insurance companies. Let's take it to the jury. If the judge was good for the goose, it's good for the geese. I want that evidence in. If the judge wants to allow this, then I will ask for thousands of lawsuits against State Farm agents and all of them for fraud. I guarantee you, I have filed more than 100. I'm sure Mr. Alex Acosta, I see his face there. His firm has filed hundreds for fraud against State Farm. Let's have them. Maybe it's going to be 1 million. And let's see here who is going to have that fraud argument.
Ms. Labinati, your point is well taken. Here, I think I understand where we are, and so being that we have a little more information, I will allow this. We don't have a final civil pretrial until June, and you guys are scheduled for trial in July. Mr. Jessup, if you need to supplement your notice based on anything that came out of the deposition or anything that has happened in the interim, I will allow you to do that quickly. Today is the 13th. So need that supplemented by 1 week. So by the 20th.
Sure, certainly, Judge.
Ms. Labinati, I'm not saying I need you to respond. If you want to respond to it, I would ask that you have that done by the 26th.
I will supplement the deposition, Your Honor, so you can have the exact date when he was released and the exact dates when he came out. So
Oh,
I will submit that by the 26th.
That's pretty much what I'm looking at. And again, I'm not going to tell you where I am in terms of the arguments. I think I know.
I
but-
understand, Judge. I feel very passionately against this. I've never had to deal with this.
I hear you. We are going to come back though on the 27th. So Ms. Labinati, to the extent you can get that to me sooner on the 26th than later. I know we have a busy criminal docket day on Tuesday. That would be helpful. But either way, I'll look at it.
I'll get it by Friday, Judge. I'll get it by Friday. I have some trial exhibits on federal court Thursday. I'll make sure by Friday.
Do what you can.
I'll
Do what
get
you
it to you.
can. I also just received the transcript, so I'll look over that again just to make sure I'm crossing my T's and dotting my I's. But I don't anticipate, unless I have questions, needing a full blown hearing. We're just going to see where we are. So we're going to reset this final status conference for April 27th. We'll probably do it at 10:30, just so I can have you on the later side of the morning docket. So if you have any questions, let me know, but please email your pleadings or responses, whatever you're going to send via email, as well as file them, okay?
Sounds
Yes,
good.
Judge.
Thank you,
Okay.
Judge.
All
Thanks,
righty.
Judge.
Thank you
Thank you.
all. Thank you. Y'all have a good day.
Thanks,
too.
Judge. Bye-bye. Alex, congratulations on your verdict. Very proud of you.
So Mr. Acosta getting a lot of shout outs today.
I don't know if that's a good thing or a bad thing, Judge.
Sounds good. All right, Mr. Marufo, who's next?
Staying on page 2, the second one, Judge. In cause number 2021 DCV 2367, Donna Moore versus Laura Macias and Guadalupe de la O. Announcement of council, please.
Alejandro Acosta for the plaintiff.
Alexandra Martinez, sorry, John. Alexandra
okay.
Martinez for defendant De La O.
And John Dickey for defendant Macias.
Okay, scheduling status conference. When in 2023, unless you're going to tell me 2022, do you want your trial?
I don't think so, Judge. We're just getting into written discovery, so we got a little bit of time to get the issues, get some depositions, and try to go to mediation at some point.
I would think February, Judge.
All righty, we can do February. How about February 3rd?
That's fine.
And that
Okay.
works for the plaintiff.
February 3rd, 2023, we'll have, am I looking at the right calendar? Oh, yes. We'll have our docket call on the 1st. You all have an idea on who you're going to use for mediator?
No, Your Honor, but we can discuss and agree on somebody.
We can agree. I think we can agree.
Perfect. We'll have our 2-week setting to have that scheduling order returned. Myrna, if we'll please get them the scheduling order. And we'll get it entered. Don't want to have to see you back in 2 weeks. Just go do what you do.
Okay.
So if you all need a hearing on something outside of those dates, let us know and we'll get you scheduled.
Thank you,
Yes,
Judge.
Your Honor.
Take care, guys.
Thanks.
Thank you, Judge.
Who's next, Mr. Perez?
I believe the fourth one on page 2, Judge.
So what happened to, first, let's go back to Mr. Chapman. I thought we had an outstanding on page 1, 0387. Mr. Chapman, I haven't noticed that this case had settled, but we had not yet received dismissal paperwork. No, that's not correct.
No, ma'am. What happened was that there is Mr. Martinez, and he's not here. I don't think anybody from the Mounts firm is, but they filed a motion to compel arbitration. I agreed to it, and an order was submitted ordering us to mediation. To arbitration. That's where we are right now. The problem has been is that, and it's not, I don't think it's Jim's fault, is that the client will not authorize him to agree on an arbitrator. So we're kind of in limbo. We've got an order, sending us to arbitration, but and normally we can agree on arbitrators, so it's not a big deal when those orders are entered. I just can't secure an agreement, whether it's with Bill Hardy or Judge Villa. I've already mediated this case and it didn't work, but we're kind of out there in limbo, and we'd like to get at least a setting in the arbitration, or at least an order, giving them a deadline. It's their arbitration clause to agree on an arbitrator, or you just order it to an arbitrator. I mean, maybe we have to set this for hearing, because I think that arbitration order was, we're off, submitting us to arbitration, case dismissed without prejudice. So I don't know if they think, and I think your court did get an email from Jim's paralegal, something to that effect.
Do we
But I was-
know
Go ahead.
where Mr. Martinez is, Mr. Marufo or Mr. Hernandez? Have we checked in? There goes Erica. I think Ms. De Leon, isn't Ms. De Leon there? But I don't want to assume. She's got my friendly suit, not the.
Good morning, Judge.
Good morning.
I am not here on this case, but I will put in a call to Mr. Martinez and his associate and see if they can jump on.
Thank you very much.
Of course.
Okay, so yeah, I'm looking at it. I don't know why that notation is there on the docket. We probably need to remove it. So the order to compel arbitration was back in March.
Yeah, it was granted, and Judge, I agreed to it. So the issue really is if you want to go on with the rest of the docket and wait for Mr.
Yeah, we'll see if
Martinez or
we
Reed.
get somebody on here and because I don't
Yeah,
want to,
okay.
obviously, if you need
Yeah.
something from us, great, but I can't imagine, for my purpose, I would probably say just put this for a status conference at 6 months and see if you all have made any headway. But, kind of just but if you all need something else from me, then let me know. But let's see if we can get Mr. Martinez on.
Okay, I'll check out and then or do you want to wait, Judge?
If you can turn off your video and put it on mute and see if we get, goes to an answer machine. Okay, maybe Ms. De Leon kind of nudging over there will help us get some response. If you'll just hang tight, Mr. Chapman, we'll be with you shortly. See where.
And I'll text Jim right now.
Okay. So maybe we can handle, is everybody here for the friendly suit?
I believe so, Judge. I got an iPhone in the waiting room. I might be Miss Ray.
Okay,
Good morning, Your Honor.
good morning. So can we check on that? Let's bring her in.
Good morning, Your Honor.
Morning. Also, Myrna, if you will put a call into Mr. Serrano and Mr. Darnell, I don't know if we bumped it up to the morning or received something on that one, the one that was set at 2 o'clock.
We haven't received anything, Judge. I'll call them.
Okay, so let's see if they can come in this morning rather than in the afternoon, and I'll talk to them. If for whatever reason, I don't know, it's kind of a holiday week. So if we do not have them, maybe we just reset them for 1 week. But let's see if we can bring them in. Okay, so, all righty. Okay, I've been having a lot of issues with my computer and I see things very, very choppy. So if you'll give me a second, I'm gonna close out some programs here and hope that I can see you all clearly. So no email, no Odyssey. Yeah, everybody is very choppy. Can you all hear me okay?
Yes, Judge.
Yeah, okay. Okay, just even closing stuff is taking a minute.
The sound stays, but your video's choppy.
Yeah, it's anytime I have like more than 2 programs open, it's, this is not closing. Maybe it's Odyssey that's giving me the problem. And I just want to make sure I have good audio. Give me 1 second. I'll be right back.
And how's your audio? iPhone. Oh, that's loud. Okay. Can you say something, ma'am?
Me? Yes,
Yes.
I can hear perfectly. Yes, ma'am.
Okay. Yeah, that sounds good. Then you can mute when you need to, okay, ma'am?
Ma'am.
Miss Ray, right? Okay.
Yes, ma'am.
Okay. So mute whenever you need to, so we don't have the background, but be ready.
All right. I hope this helps. I still see you all very, very choppy. All right, let's go ahead and get started. Is everybody ready?
Yes, Your Honor.
Yes, Your
Honor.
All righty. Mr. Mutterful, if you'll call it, please.
In cause number 2021 DCV 2421, Myra Ray et al. Versus Samuel Hernandez Acosta. Announcement of counsel, please.
John Carlos Center for Plaintiff, Your Honor.
Your Honor, good morning. Felicia de Leon Rendon on behalf of the defendant.
Good morning, Your Honor. Soraya Yanet Hanshu, guardian ad litem on behalf of the minor.
Okay, good morning. This is a continuation of the hearing. I actually don't remember what the date was, and I don't have Odyssey open anymore. I'll just let you know I'm having several issues with the computer, and so everybody is very choppy. I apologize. I may need to interrupt you if I am not hearing things. But the court had initially asked to have this be an in-person hearing reset. We had some issues with that in terms of our witnesses, and because of further issues, I have agreed to reconvene this remotely. However, yeah, now I'm having some issues. So let's see if we can get through it. If memory serves, I believe Ms. Hanshu, you were asking questions. And so Ms. Myra Ray, I will just remind you that you continue to be under oath as you testify today. And Ms. Hanshu, you may continue if you remember where you were when you last.
Thank you so much, Your Honor. I also wanted to let you all know, I just emailed Your Honor as well as counsel an updated version of the guardian ad litem findings. It now reflects we're back here again. And I also attached the letter that I intend to provide to the district clerk's office. I thought we'd be there in person, so the letter reflects it's a hand delivery, which I can still do without a problem. Ms. De Leon Rendon may send me a check if she needs to, or we can meet downtown, whatever works. And that's all for everyone's review before the end of the hearing, just to ensure that we've got all of our paperwork in order. Now, Ms. Ray, I'll just reinitiate what we were discussing for purposes of the court before this hearing was suspended. If you could please state your name again for the record and spell it.
And Miss Ray, you're on mute still. If you can take yourself off of mute.
There you go.
You hear me now? Okay. Myra Ray, Mayra-Rey.
Miss Ray, do you have a daughter?
Yes, I do.
What is her name?
Dayanara Christine Rodriguez.
You previously testified that Dayanara was in a vehicular accident, is that correct?
Yes, ma'am.
And was she injured as a result of that accident?
She had a concussion, 2 concussions.
Did she receive medical care?
Yes, she went to a chiropractor after that.
And as of now, is she in need of any additional medical care in regards to these injuries?
No, right now she's doing much better.
Has she resumed all of her regular activities?
I'm sorry, I did not understand you.
Has she resumed all her regular activities, gone back to her regular life before the accident?
Oh, yes, ma'am.
And you understand that you are here to present to the court a potential settlement for.
I'm sorry, Ms. Lynch. There is some background noise. It's Miss Ray, do you have 2 devices going?
No, it could be the outside. I can move myself.
Okay, I'm not sure, but we're hearing a echo of the proceeding. So I'm just gonna mute her for a second. I'm pretty sure it's coming from, I don't know why there would be that type of echo, but just.
Let me say something to make sure it's not me.
Uh-huh.
Okay, it's not me.
No, it's not you. I'm pretty sure it's Miss Ray. Okay, so Miss Ray, if you would please unmute again. Let's see if we can hear.
Much better.
Yes. Yes.
Go ahead, Ms. Sanchez. Go ahead.
Thank you so much, Judge. I still hear the reverb.
No.
You have something, ma'am, Ms. Ray, it's like you have a speaker on, you have something that is echoing you too much. I mean, the acoustics are crazy there.
I don't know that that's, yeah, that's.
Unless you have a TV, you have it on YouTube on, then you've got a double feed.
Yeah, there's a full repeat and it's making it difficult to hear her real-time answers or questions. So.
Okay, did you turn off any secondary Zoom you've got going? Ms. Ray?
I cannot hear you.
You cannot hear me?
No, ma'am. Just a little bit.
Okay, where are you Zooming from?
I am from Midland, Texas.
No, but what device are you utilizing for the Zoom?
An iPhone.
Okay, can you turn up the sound on the iPhone as much as you can?
Okay.
Did that improve?
I turned it up all the way.
Okay, can you hear me now?
Yes, ma'am.
Okay, that's much better. Let's go with
A
this.
little bit, yes.
Do you understand that the gross settlement amount regarding Dayanara's accident was $12,268.31?
Yes, ma'am.
And you understood that your attorney, that is also Dayanara's attorney, at least for purposes of the settlement, reduced his attorney's fee to 25%, only being paid $3,067.08 for this matter.
Yes, ma'am.
And you understand that the same attorney paid all outstanding medical liens for Dayanara's medical care.
Yes, ma'am.
And the total of that amount was slightly under $7,000. Is that correct?
Yes, ma'am.
I won't go through the itemized amounts because we had to testify to your understanding of those individual liens last time we had you testify. But you also understand that the plaintiff's counsel had those liens reduced and negotiated on behalf of yourself and Dayanara so that those liens were satisfied for a lesser amount than they were billed.
Yes, ma'am.
And is it your understanding there are no other medical liens available and or pending regarding Dayanara?
Yes, ma'am.
Pursuant to the settlement, do you understand that Dayanara will receive $2,410.30?
Yes, ma'am.
And because Dayanara is a minor, do you understand that a check for that amount will be provided to the district clerk's office in El Paso County?
Yes, ma'am.
And the district clerk will hold this amount in an interest-bearing account until Dayanara is 18 years of age.
Yes, ma'am.
The monies that are being set aside and invested in an interest-bearing account for Dayanara are solely for her use. Do you understand that?
Yes, ma'am.
And per our prior discussions, please confirm with the court that you understand that when Dayanara turns 18, she is to bring a ID with her to the county district clerk's office in order to retrieve her funds, which will reflect this initial deposit plus any interest earned between now and when she turns 18.
Yes, ma'am.
And when she receives those funds will solely be released in her name and for her use and are not your funds.
Yes, ma'am.
And are you in accordance or in agreement with this settlement?
Yes, ma'am.
And you testified today, Dayanara does not need any further medical care regarding her injuries.
Yes, ma'am. No more.
And you understand that accepting the settlement before the court will end this case completely?
Yes, ma'am. Correct.
And you will not be able to sue defendants again regarding this accident?
Yes, ma'am.
And you understand you will not be able to sue anyone again regarding the circumstances related to this accident that are being settled before the court today?
Yes, ma'am. Correct.
And are you asking today for the court to approve this settlement deal?
Yes, ma'am.
Is it your wish to accept this money and have Dayanara accept this money through myself, her guardian ad litem, in order to end this case?
Yes, ma'am.
Thank you. I pass the witness.
Your Honor, I have just a few questions, if that's okay.
Yes, ma'am.
Okay. Good morning, Ms. Ray. My name is Felicia de Leon Rendon, and I represent the defendant in this case, Samuel Hernandez Acosta. Do you understand that?
Yes, ma'am.
Okay. And Ms. Hanshu went over most of the questions that we needed answered today. I just have a couple more for my purposes. To confirm, you are the natural parent of Dayanara Rodriguez. Is that correct?
Yes, yes, ma'am.
Okay. Now, do you understand that you and Dayanara have an absolute right to have your case tried by a jury?
Yes, ma'am.
Okay. And you understand that a jury could award more, less, or the same as the amount of settlement money that is being offered here today. Is that correct?
Correct.
Okay. You understand that if the court approves of the settlement, then you will never again get to sue the defendant for any claims arising out of this accident, correct?
Correct.
And you further understand that you cannot come back later and ask for more money, correct?
Correct.
Okay. And is it correct that you're prepared to settle your claims as well as Dayanara's claims for the alleged damages sustained by you and your child?
Yes, ma'am.
And that also includes any claims for any potential injuries that might arise or develop due to this incident, correct?
Correct.
Okay. And you understand that you'll be asked to sign a release and indemnity agreement on behalf of the Ayanara and in your individual capacity. You understand that, right?
Yes, ma'am.
And Ms. Henshu went over the distribution of the money and the outstanding liens the last time we were here. But do you understand that any other liens for medical bills and expenses or services provided to the Ayanara that are not mentioned in the final judgment or in that release that we just discussed will be your responsibility as her parent and next friend?
Yes, ma'am.
And you agree that this settlement will be in the best interest of your child, correct?
Yes, ma'am.
Okay. At this time, Your Honor, I pass the witness.
And we have no questions, Your Honor.
Answered my question, Mr. Serna. Okay. Well, thank you to all of you for being so accommodating, and Ms. Ray, thank you very much as well. Of course, I have reviewed and did receive the updated report. The settlement will be approved, so including Ms. Hanshu's fee for services. And so thank you for just helping move this along, because I did see there was an ongoing depletion of the resources as time went on. So we needed to square this away ASAP. In any event, if you will, please forward any conforming documentation, email it to both Ms. Hernandez and myself, and that way we can get everything taken care of. Other than that, Ms. Ray, thank you. I hope your daughter is doing well and continues to do well. All right.
Thank you.
Thank you very much. If there's nothing further, then we're adjourned on this matter.
Thank you so much, Your Honor.
Thank you, Judge, for being so accommodating on this case.
No worries. Appreciate your help.
Yes, thank you very much.
Appreciate your help.
Felicia, call me and we'll deal with the check.
Okay, thank you so much.
Thank you all.
Bye.
All righty. I see Mr. Serrano and Mr. Estrada was there somewhere. There you guys are. Okay. Thank you. We had you at an afternoon slot, which is very, well, no, it's not unusual, but you were the only ones. And considering it's going to be Good Friday, all those things, I said, well, if you can come in the morning, let's do that.
Yes,
So
Judge.
calling 2021 DCV 0749, Jorge Rivera versus Arturo Garcia Medina. I have announcements.
Victor Serrano on behalf of defendant, Your Honor, of the plaintiff.
Chris Estrada for the defendants, Your Honor.
Civil day, Mr. Serrano, not criminal.
I know, Judge.
All
Judge,
right. Monday.
On this one, I'm filing as we speak a notice of non-suit with the order.
I'm going to make you stay here until Miss Rios accepts it. All right. That's where I thought we were. And so happy Easter. Thank you very much. Ms. Rios, send it over when we're done, when it's good to go meeting. Okay. Thank you guys. Take care.
Thank you.
Have a good weekend, Your Honor.
Have a
You
good
too,
weekend.
take care. Mhm. All right. So, Mr. Chad, do we get anybody? Oh, who's is that?
He's in the wrong court. He's supposed to go to CC1.
Reed Rendon?
Mhm.
Okay. So we can kick him out, right? If he's not for us.
Yes, ma'am.
Well, I think he is, Judge, I think he's here. He's Jim Martinez's associate on this Luna case.
Oh, okay. Let's bring him in. Let me see. 2746. I've
That's
lost
all.
you guys.
That cause number refers back to CC1. CC7, excuse me.
Okay. Mr. Rendon, are you here for Mr. Martinez?
Yes, Your Honor. Good morning,
Okay,
everybody. Sorry
perfect.
about-
So let me see, between all my technical issues and everything, I'm not quite remembering everything Mr. Chapman told me. But we needed someone here, Mr. Rendon. So I hear you guys are stuck. Do you all need something from me or what's going on?
Well, Judge, just to recap, this is a case against a home builder. I represent the plaintiffs. The home builder has a valid and enforceable arbitration clause. Jim Martinez and Reed filed a motion to compel the arbitration. I agreed to it. The order ordered us to arbitration, dismissed the case without prejudice. The issue that we're having right now is the parties are either, well, I've proposed two arbitrators, Judge Villa or Bill Hardy. We've already mediated with Judge Ancliffe, and my client is all over me about getting an arbitrator appointed and getting an arbitration date. And I don't know if Reed and Jim are having trouble getting an agreement from their clients or where we are on that.
Yes, Your Honor, and I think I agree with everything Mr. Chapman said. Right now, we have let our clients know about both of those proposed arbitrators, neither of which we have a problem with. Obviously, we do a lot of work with both of them, but we're trying to, get our client to agree to either one. It just hasn't happened yet. And as to the date, I don't know if one has been proposed, but I know Jim's calendar and mine are both open for October, if that works with you.
Yeah, and that's fine. I mean, I think the main point is I would just like, if the judge would, just to hold your client's feet to the fire, maybe set it for another status in 2 weeks or 30 days, just to make them make a decision. Then we'll deal with the arbitrator's schedule and our schedules after that. I just need a forum to move this case along.
Sure. So I because of my technical issues, I have tried to keep I've had to close everything out. So Myrna, do we have a setting in 30 days or close to 30 days or in 2 weeks? I don't recall from memory what the settings were on this case. So this is, a ver, let me find it. 2021 DCV 0387.
Despite my Zoom name, yes.
Yeah, I know. That's what had everybody. You were going to stay in the waiting room forever, Mr. Evans.
There are no future settings on that, Judge?
Okay, so we'll do, let's see. Why do I keep forgetting? 13. We'll come back on May 11th,
Okay.
10:30. Okay,
Okay. Thank you.
beautiful. Thank you very much.
Thank y'all.
Bye.
Sorry.
Thank
for
you.
making my way.
No worries. Okay. Thank you.
Take care, guys.
Okay.
All right. So that should be everything, right? Is that everything? No, we have
The
418.
1015 judge
Mhm.
on page 1. I've been unsuccessful in contacting their.
Let me, I don't have Odyssey open. Let me close this out. Let me see if I can get back into Odyssey. I think Odyssey is the problem because even when I opened Task Manager, it didn't let me close it. A ver. We can get off of YouTube though. Let's get off of YouTube.